And now I would like to hand the conference over to Judy Bernstein. Please go ahead.
Good afternoon. As you just heard, this is our webinar, Managing Mass Torts, Less is Definitely More. This is the third of our 4 webinars on mass torts. We have 3 speakers today. First, Peter Grassi will present ways to consolidate lawsuits into 1 or 2 jurisdictions by various methods, which includes removal, motions for fraudulent joinder, and MDL procedures. Peter is former chair of A&P's litigation department. He was named the senior statesman of the National Product Liability Bar by Chambers each of the last 5 years. Peter is currently on the law school faculties at Harvard, Penn, and UVA, where he teaches courses on product liability. Second, Carrie Arnold will discuss pre-discovery methods of gathering information on plaintiffs with a focus on Lone Pine questionnaires. Carrie is a partner here at A&P. She's been involved for a number of years in pharmaceutical and tobacco mass torts. Carrie is currently managing as well as trying the Engel tobacco cases in Florida. And in cleanup, third, we have Daphne O'Connor, who will discuss ways to defeat medical tests and diagnoses commissioned by plaintiffs' counsel. Daphne is Vice President and Associate General Counsel of Altria and a former A&P partner. Daphne has had extensive experience managing and trying both pharmaceutical and tobacco cases. Please use the chat tool today that's within your WebEx to ask questions throughout the program. If we have time, we will try to answer your questions. But if we don't get to your questions, you can contact us after the call, and we'd be happy to answer them for you afterwards. As you just heard, your lines are muted, but if you do need help, press star, then 0, and you'll get assistance. This event is being recorded and may be posted on Arnold & Porter's website, or will be available to the public. For your convenience, shortly after the program, we will send a link with presentation materials to all the participants of today's program. And lastly, I want to announce our 4th webinar in this series, Mass Tort Litigation, All's Well That Ends Well. Details will follow on that program. I'm going to turn it over to Peter Grassi.
Good afternoon. As Judy said, I'm going to start out by discussing methods for corralling or controlling mass torts that are filed all over the country. And obviously the point here is that if you can get hundreds or maybe even thousands of cases organized in 1 or 2 favorable and more fair jurisdictions, you can then employ some of the techniques that Carrie and Daphne are going to be talking about to winnow and reduce the number of the cases overall, to make sure that discovery is done efficiently and fairly, and to be sure that when the cases are ultimately tried, they're tried in some fair manner. The first problem, of course, though, is that that's exactly what the plaintiffs don't want. They have been very clear over the years about the fact that they want to follow something called a wolf pack strategy. And this indicates that even when the plaintiffs are actually coordinating their activities, as they used to at ATLA, or I guess now they like to refer to themselves as the American Association for Justice, they will nevertheless file cases all over the country in favorable courts to them. And so I'm sure many of you have found yourself in places like West Virginia, Beaumont, various portions of Mississippi, and then, of course, always Madison County, the one in Illinois, not the one with the bridges that we all like so much. And you find yourself there before very pro-plaintiff judges, very pro-plaintiff juries, and you end up litigating the cases over and over again at the pace that the plaintiff attorneys want to pursue. This allows them to take multiple shots at such things as company depositions or document production. It allows them to seek out the more favorable judges when you have the important legal issues like Daubert challenges or various kinds of causation motions. And then, of course, they get to pick their time and their place of trying cases in front of favorable judges and juries. This is all presumably to then force some large mega settlement where you're not really able to deal with the individual facts and hopefully the individual weaknesses of each case, but rather you have to go ahead and settle them all simply because you've been chewed up in all the various locales by the wolf pack. And so what we need to do on that as defense counsel is respond in a more coordinated and a more centralized way, preferably, ideally, to corral and coordinate as many cases as you possibly can in one fair MDL court. And of course, once you do that, once you bring your cases to the individual district courts around the country, you have a very good possibility of having an MDL appointed in one place and bringing all the matters before that one judge who has the time and the ability and hopefully the independence of lifetime tenure to consider the cases fairly, as opposed to some of the political things that you find in the hinterlands where you have very often elected judges, very parochial situations. There's also a side effect to this, or a beneficial side effect, in that if you're aggressive in a removal strategy to federal court, over time the plaintiff attorneys recognize this, and they will sometimes make the lesser choice of filing their cases in the state court, which is your home. For example, in the case of American Home Products and Wyeth and the diet drug cases, we found that by being aggressive on federal removal, the plaintiffs saw that, and so they brought cases in the Philadelphia Court of Common Pleas in Philly, or in New Jersey, the two home fora of American Home Products. This is not as ideal as having all of the cases in one federal court, but it's obviously better than having scores, perhaps even 100 different courts around the country where you have no local presence. And then again, in those courts such as Philadelphia or New Jersey, they're also familiar with this phenomenon, and you can get somewhat coordinated treatment there. So you're dealing with maybe 2 or 3 main courts in which you have to operate. Now, some of us tried to do this and get involved with this in 2005 when the Congress passed the Class Action Fairness Act, which I'm sure many of you are familiar with. And if you are, you know that there's a provision in that act that is supposed to apply to something known as mass actions or mass tort actions, generally defined as 100 or more lawsuits with a common nucleus of fact or law. Those of you who have dealt with this, however, know that in the past 5 or 6 years, this has become something of an empty promise. The plaintiff attorneys are clever enough to be able to file these lawsuits in groups less than 100, very often individually or in small numbers. And unfortunately, the courts have not been willing to aggregate these cases at the request of the defense. It's still something of an open question in the law, but very important jurisdictions like the Ninth Circuit, the Seventh Circuit, have held that they simply will not aggregate these cases, that when Congress said 100, it meant 100, and they will not, at the defense initiative, put those cases together. And so as a result, the defense bar has to fall back on the old-fashioned forms of federal jurisdiction, most obviously diversity jurisdiction. And on paper, this should work, since generally these are cases brought by citizens, plaintiffs of one state, against a defendant who is not a citizen of that state, who has his principal place of business and his state of incorporation in some other state. And I think that to some extent, the defense bar has been too passive about the importance of diversity jurisdiction. I like to go back to the very beginning and talk about the fact that diversity jurisdiction, which you can find in your pocket constitution, Article 3, Section 2, is one of those fundamental rights that we're supposed to have in this federalist system. And you can go all the way back to the comments of Alexander Hamilton in one of the Federalist Papers, where he argued in favor of a national judiciary who would provide an impartial, fair tribunal where you do have the suits between citizens of different states. And I think it's good to remind the court sometimes that the defendants really do have this right to diversity jurisdiction. It is not merely a matter of congressional largesse or judicial largesse. It's not a mere procedure. It's something that you're really entitled to. Now, of course, the problem there is that the plaintiffs, the Wolfpack, have figured out ways to try to avoid diversity jurisdiction. And what I'll be talking about for the remainder of my time is the issue of fraudulently joining a local defendant. As you all know, if you were paying maybe a little more attention than I did to my first year civil procedure class, the courts fairly early on developed the idea that what the Constitution meant by diversity jurisdiction and the way Congress has enacted it in the various portions of the judicial code requires complete diversity. And the plaintiff can defeat that diversity jurisdiction by nominally and perhaps fraudulently naming one local defendant, a doctor, a pharmacy, a sales representative, who of course is of the same state as the local plaintiff. They then take advantage of that by holding that nominal local defendant in for generally 1 year and 1 day, at which time they will often dismiss that defendant to simplify the case and make it more palatable for trial. Why did they wait a year and a day? Well, unfortunately, in 1988, Congress passed what I like to call a mini statute of limitations on removal. And Section 1446B of the Judicial Code provides that, on the one hand, you have to act fairly quickly within 30 days of whatever pleading, and it can be a pleading, it can be a complaint, sometimes it's an interrogatory answer, advises you that you now have complete diversity, and you have to act within 30 days of that, so you have to always be aware of those developments. But then they added, thoughtfully, that a case may not be removed on the basis of diversity jurisdiction more than 1 year after the commencement of the action, the filing of the complaint. Some of you old-timers in the audience may remember that it wasn't always thus. And as a result, you could wait until the eve of trial, or perhaps even during the course of the trial, develop the facts that the plaintiff was dropping his case against the local defendant, and then immediately seek removal. And this struck some people as a little bit last minute, and that's why in 1988, presumably, allegedly, Congress added this provision. And unfortunately, most of the courts hold that even in cases of fraudulent joinder, the rawest kind of improper joinder, you still can't remove after 1 year from the filing of the action. So what I'm going to be preaching for the rest of the time here is that you have to be very vigilant, you have to be very aggressive in developing the facts during that first year that allow you to convince the court that in fact the joinder is fraudulent, the diversity is really complete, and you should be allowed to remove the case. Let's talk very briefly about some of the case law on fraudulent joinder. It's quite old as well. It can be traced as far back as the Wilson case from 1921, where the court recognized, as shown on the screen, that although it may appear to be fair on its face, if it is truly a fraudulent joinder, the courts can look through that and can permit the removal to succeed. And again, there's a little bit longer article about this that we wrote a few years ago, and we also have some updated research, and I guess you'll be getting some of that in the materials that will be provided. But the courts are fairly clear that this is always a possibility. The problem is, however, that many of the courts have taken a rather restrictive view. They essentially equate it with a motion for summary judgment, and they will say that the mere possibility that the action is brought properly against the local defendant will defeat removal. And they use such phrases as having a heavy burden on the removing defendant to demonstrate that the joinder is in fact fraudulent. What we found when we were fairly aggressive about this, primarily in the diet drug cases, is that you can get courts, however, to take a somewhat more realistic and practical view. And there are two prongs that we developed in that law that I think are pretty good law that we'll discuss for the remainder of my time. The first is basically a legal approach. This looks objectively at the facts of the case as developed by the pleadings, and it will determine that the joinder is fraudulent if there is no reasonable basis. It's a pretty high standard, but that there's no reasonable basis in fact or law for even a colorable claim to exist against the non-diverse defendant. And I'll take you through some of those scenarios in a moment, and you'll see that it's in essence a summary judgment type of standard. The second independent prong, and it is an independent prong, is the idea that there is no real intention on the part of the plaintiff attorneys to bring a good faith case, to pursue a good faith case against the non-diverse defendant. And at the end, I'll show you some of the hallmarks of that. Now, these are independent prongs. You can use either under the law. It's very good if you have both. Obviously, to argue to the court that there's really no colorable basis for a claim, as further demonstrated and punctuated by the fact that the plaintiff has not been taking the claim seriously is perhaps the best way to go. And as I said, this is something that we developed in the diet drug cases. We were fortunate in a sense that we had an extensive track record in the first phase of the litigation, which took about 4 years, from 98 to 2002, demonstrating that in some cases the plaintiff attorneys were not sincere in bringing these cases against the local defendant. So starting around 2002, after we developed and marshaled all those facts, we were able to remove a great many of the cases that were filed in the second round, starting in 2003. And as I said earlier, we already were benefited by the fact that the plaintiffs filed many cases in the local courts in Pennsylvania and New Jersey to avoid this rather aggressive approach that we took. But we were still able then to remove about 20,000 more cases from various state courts around the country, first to the local federal court, but then very quickly with promises that we would take them to the MDL federal court in Pennsylvania. And that, even though the litigation was extensive, that coordination in those three courts allowed us to some extent to coordinate both the discovery and the trial phases of those cases. So let's talk a little bit about the most popular sham defendants, and I'll focus to some extent on pharmaceutical cases, but you can see, I think, the cognates in other sorts of mass tort cases as well. And the four that we're going to discuss are pharmacies, sales representatives of the prime defendant, that is the defendant they're really going after, other manufacturers who may have local citizenship but make the same drug, or in the case of diet drugs, a combination that was used in those cases, and then of course local physicians. Starting first with the pharmacies. What typically happens here is that the plaintiff will find a local pharmacy who gave the pills to one or more of the local local plaintiffs, and will name them as a nominal defendant in the case. Typically, they make no special allegations against them. They just lump them in with the allegations that all of the defendants somehow misled the physician and somehow misled the ultimate patient. The fact of the matter is that this type of sham, fraudulent joinder just should not succeed under the laws of the various states. If you check your statutory law on the indemnity and immunity of pharmacists, if you look at your case law to the same extent, what you find is that as a variant of the learned intermediary rule, which of course requires that in prescription drugs the warning be given to the doctors, not directly to the consumers or the patients, as a cognate of that, the courts very consistently hold that a pharmacy who simply fills a prescription, does nothing more than count out the pills and puts on the label the accurate information, take one every 4 hours with a meal, is in no way involved in the warning process and is in no way liable for that warning process. And so unless the plaintiff is able to demonstrate some specific act of independent negligence by that pharmacist, that case should be dismissed against the pharmacist, and then of course their joinder should be ignored. And there are a number of litigations that have followed this rule, and I think you can be fairly aggressive in doing that. What you need to do sometimes is bring it home through the plaintiff's liability expert. And again, within that 1 year time frame, it's important through answers, interrogatories, and especially the deposition of a plaintiff liability expert to confront the plaintiff with, in essence, a difficult choice. Are you saying, sir, that the pharmacy did anything wrong in this circumstance? 99 times out of 100, the plaintiff and the lawyers and their liability experts will not want to pick a fight with the local pharmacy. They probably can't pick the fight in the first place, but for political jury reasons, they won't want to pick the fight. And so they will acknowledge that, in fact, the pharmacist did nothing wrong. And once you have that, you have your ability to go to court, remove the case, and argue that that is a fraudulent joinder. And that'll be the theme in these other instances and examples as well. The second one I'd like to talk about is sales representatives, and this applies, I think, across the board, not just to pharmaceutical companies. This is a common move by plaintiffs to pick a local sales manager or a sales rep who obviously has the same residency and citizenship as the local plaintiff, and named them in the lawsuits. The courts are a little bit more split on this, but again, I think the law favors the removing defendant because most courts will recognize that a sales representative who does nothing more than pass along the literature or the label of a manufacturer cannot be held independently liable for that conduct. There's two ways of looking at this. One is the old-fashioned law that says that an employee, a sales representative, cannot be viewed as an independent agent for purposes of conspiring or conducting a tort along with his manufacturer. They recognize that they are simply the agent of the manufacturer. Other courts have looked at it a little bit more precisely and have focused on old-fashioned notions of the ability or the lack of ability of the sales representative to really make a special profit. They recognize they're not independent contractors, they're not middlemen. They once again are simply passing along the product, or indeed not even touching the product, just passing along the warning information without any independent existence. And one way or the other, the courts are generally favorable in eliminating a sales representative. Once again, you may need to push the plaintiffs through interrogatory answers or the plaintiff's liability expert to make it clear that they really have no special independent grievance against the sales representative. And again, in most cases, they will give that up fairly easily. The third group I want to talk about, it gets a little more dicey, is when you have another manufacturer involved in the case. Now, logically, there can be two possibilities here. One is that the other manufacturer, perhaps a generic manufacturer, is making the same product. And you have these situations where increasingly these days people are suing across the board the makers of both the brand name product and the generic product and saying we have to sort that out closer to trial. Or you may have the kind of situation we had in diet drugs where you had another drug that was being used in combination. The fen-phen combination, fenfluramine was the drug that our client made. The phentermine manufacturers were legioned. It was a generic product, and they ended up being located in just about every single state. So it was common for the plaintiffs to name the local manufacturer of a generic phentermine and then argue that they were somehow involved in the case. You approach those two things, I think, a little bit differently. In the case of the generic manufacturer of the same product, what you want to be thinking about is the developing law with respect to the limited exposure of any generic manufacturer where they simply follow the label warning. And I'm sure all of you in the pharmaceutical field are well aware of the Mensing case from a couple of years ago, where by and large it was held that generic manufacturers would not be liable when they sold the same product with the same label. I'm sure some of you are also familiar with the Bartlett opinion that cut back on that a little bit this past summer in the First Circuit. And of course, that case is up and I think will be argued in a couple months in front of the Supreme Court. But depending upon how that comes out, the generics may once again have a very good legal immunity from this kind of lawsuit. And it will be important to develop that again within the first year. In the case of the other drug with another manufacturer, in the phentermine case, what you need to do is once again present the liability experts and especially the medical experts with a Hobson's choice. Are they really going to go after the phentermine manufacturers, the other person that they're really not that interested in? If they do, that opens up a big hole in their causation case. Hopefully, again, as in phentermine, I'll discuss this in a minute under the other prong, they will acknowledge that they really don't have a basis to go against that other unrelated or separate drug. And finally, in terms of the big four that we're going to talk about, there are the prescribing physicians. This, of course, is also a very common fact pattern where a plaintiff, to try to avoid diversity, will name the local physician who did the prescribing. Now here, this is obviously more fact intensive because there could be a case against the prescribing physician. It could be alleged and proven, for example, that they did not follow the label with respect to dosage or with respect to contraindications, how they should properly use the drug. Or perhaps there's even a claim that they did something else independently wrong, such as fail to diagnose or monitor a side effect or a condition. These are logical possibilities. The point is that you must confront the plaintiff and their experts with the choice. Are they going to lay it off partially on the doctor, or are they going to go after the drug company alone? Except in those cases where there really is a basis to go after the doctor, most of the plaintiffs will tend not to want to go against a local doctor who has a nice reputation, who has birthed half of the babies of half of the local jurors, and they will want to go after the drug company alone. And again, once they do that, you're in a position to go to the court and say that the prescriber has to be dismissed, or indeed that his jointer has to be ignored. In the few minutes remaining, I want to talk a little bit about the other prong of all of this. And this is a demonstrated lack of intent on the part of the plaintiff's attorneys to really prosecute a claim to verdict. This is a more subjective standard where you're focusing not on the law, but you're focusing on the conduct of plaintiff's counsel. Now, this is something you can't do in your very first lawsuit. You need a track record. And what I want to say is that it's very important for defense counsel in these mass tort situations to keep track of what the plaintiff attorneys or their common experts have done in prior cases, because it's an independent basis to ignore the sham defendant. And as I said, it can also be a good punctuation for your legal claim. Now, how might this arise? These are all different possibilities, and we saw most of them in diet drugs. The first is simply repeated dismissals of the sham defendant by the same law firm. What you see is a pattern where they're always naming local doctors, or they're always naming a drug company that makes a different drug, or they're always naming local pharmacies, maybe even the same pharmacy. And then, lo and behold, wonderful to recall, within 1 year and 1 day of all of those lawsuits, they dismiss those cases. If you keep track of that kind of conduct and present it, we presented it in grids in the diet drug cases, to a good judge, he will or she will get the message, and they will realize that this is a sham designed to defeat removal. On the discovery front, you often get this where the plaintiff counsel just don't serve any discovery against the local defendant. That becomes pretty clear over time that they're not serious about it. Sometimes common experts, the same experts in the case, will make statements in case A where it's clearly indicated that they have no general grievance against these pharmacies or against these other companies. You can use that in case B to show that they really don't have an intent to proceed. Sometimes there's inexplicable conduct, that's what they called it in diet drugs, where the local defendant does not cooperate in removal, even though everyone knows it would be best to get out of that local court. Savvy judges, practical judges will look through that and recognize that there's something going on, basically a knowing wink between the local defendant and the plaintiffs, that if they put up with it for a year and a day, they will be dismissed without any kind of liability. And sometimes you actually, as we did in diet drugs, are able to take discovery and demonstrate that there is an actual agreement between the local defendant and the plaintiffs to just play this game. The courts appropriately should reject that and find that that's all a sham and it's all a fraud. So just to sum up, what we've been saying is the effective management of these kinds of cases requires some kind of docket consolidation and control, and that in most cases, because CAFA just won't help you, in most cases that's going to require very vigorous, very prompt enforcement of diversity jurisdiction, very often by voiding the fraudulent joinders that the plaintiffs will otherwise arrange. So with that, I'll turn it over to Carrie, who I think is going to talk about another technique for winnowing and reducing the number of cases.
Good afternoon, everyone. Thank you again so much for joining us today. I'm sure that many of you have been involved in some of these mass tort cases and suspected that for whatever reason, some number of the claims that you're facing are just not legitimate. I'm going to be talking today about Lone Pine questionnaires, which is one of the procedural tools that can be used to identify and potentially even eliminate some of those illegitimate claims. And to explain exactly what a Lone Pine questionnaire is, I'm going to start by giving an overview of the Lone Pine case, which really is the origin of this procedural device. So in Laura versus Lone Pine Corporation, which was a case from 1986 out of a state court in New Jersey, there were a number of plaintiffs who brought both personal injury and property depreciation claims against a large number of defendants who owned and operated a landfill, the Lone Pine landfill. It's important to note that early in that case, defense counsel brought to the attention of the court a government report, a record of decision by the EPA, which evaluated the Lone Pine problem and identified the location of the potential pollution. Well, this report really called into question the basis of plaintiffs' claims. So at a very early case management conference, the court ordered plaintiffs to complete questionnaires and to provide information and documents to describe or to demonstrate the basis for their claims. And this was ordered before the initiation of discovery. For each of the personal injury claims, the court required plaintiffs to provide documentation and facts supporting their claims of individual exposure to the alleged toxic substances. The court also required for personal injury claims that each plaintiff provide a report from a treating physician or another expert explaining the basis of plaintiff's personal injury claim. For the property claims, the court required plaintiffs to identify the property that they claimed was damaged and reports of real estate or other experts, again, supporting the basis of that claim. The court in the case really was far from impressed with plaintiffs' responses, and it found that the information that plaintiffs provided on the personal injury claims was, quote, so inadequate as to be deemed unbelievable and unreal. In fact, the plaintiff's attorneys complained to the court that, well, the doctors that I talked to, the doctors that we contacted were just unwilling to commit to a causal connection. And the court asked rhetorically, well, if they're unwilling to support your claims, who can provide the information? With respect to the property claims, the court stated that the information provided was woefully and totally inadequate. So defendants moved for dismissal for failure of the plaintiffs to comply with the court's case management order, and the court dismissed the case with prejudice. In its decision, the court explained its reasoning as follows. It said, in this court's opinion, it's time that prior to the institution of such a cause of action, attorneys for plaintiffs must be prepared to substantiate to a reasonable degree the allegations of personal injury, property damage, and proximate cause. And this quote really captures an overriding Rule 11 theme that we see in decisions where courts order plaintiffs to complete Lone Pine questionnaires. That is, that plaintiffs should be required to confirm the basic facts of each individual plaintiff's claims before they file a mass complaint or a class action complaint against defendants. Since the Lone Pine decision, Lone Pine orders have now been used what courts have described as fairly routinely to manage mass tort cases. And we've seen Lone Pine questionnaires used in a number of types of cases, including environmental and toxic tort cases. We've seen them used in a fracking case out of Colorado. We've seen them used in an Exxon oil spill case. A number of pharmaceutical cases, including Vioxx, Avandia, Resolin, Fosamax, which is one of the decisions I'm going to talk about at the end of my presentation, and in some consumer class action cases, including the tobacco litigation that Judy mentioned that we all have been involved in down in Florida. You can see from this list up on the screen that a number of federal courts have both used and approved Lone Pine questionnaires, including the Ninth Circuit Court of Appeals, including the Fifth Circuit Court of Appeals, and including district courts from all of the states that are listed here. And a number of state courts have used them as well. In each of these opinions, the courts have explained the purpose of these Lone Pine orders as follows. And this is a quote from the Vioxx litigation from the Eastern District of Louisiana. The court has said that the basic purpose of a Lone Pine order is to identify and cull potentially meritless claims and streamline litigation in complex cases. And you'll see in reviewing the opinions that these Lone Pine questionnaires are used most often when there's some question raised about the legitimacy of the individual cases in a mass tort. So, for example, in the Lone Pine case, we saw a question raised from that government report, which made it seem questionable, which raised questions about the legitimacy of each individual plaintiff's claims. Lone Pine questionnaires have been used in cases where there's a pattern of voluntary dismissal by plaintiffs as the cases undergo further and further scrutiny. So If plaintiffs are voluntarily dismissing their cases when they're activated for discovery or when they're set for trial, a court may decide that the remaining cases really should be subject to these additional requirements. And courts have noted that these questionnaires really can benefit defendants and plaintiffs, although plaintiffs' counsel certainly resist these questionnaires. The reason being that these cases, as everyone on the phone knows, are very expensive and costly to litigate, and that by focusing in on the cases that are truly meritorious, all parties and the court are going to reap some benefits. Other benefits that courts have identified is that Lone Pine questionnaires can provide. It can help identify cases for bellwether trials. It can help to identify cases that are ready to be remanded to home districts. And in some cases, Lone Pine questionnaires can be used to clarify pleadings in mass complaints where, for example, the plaintiff's counsel did not identify the diseases or the injuries claimed for each of the individual plaintiffs. Is there any specific authority for Lone Pine orders? There's not. There's no federal rule that expressly authorizes the use of these questionnaires. And typically, federal judges entering Lone Pine orders have based their decisions on their wide discretion to manage discovery under Rule 16. And they specifically cite Rule 16, subsection C2L. And for those of you who, like me, who don't have that committed to memory, I've pulled that up on the next slide. And I have not seen any case in which a court found that it did not have the authority to require a Lone Pine questionnaire if it wanted to. So what kinds of information have plaintiffs been required to provide in Lone Pine questionnaires? Usually the questionnaires are focused on issues of general or specific causation, but really a variety of other issues have been addressed. Most often, courts will require plaintiffs to provide the basic facts of their case that you might otherwise see plaintiffs providing in a preliminary fact sheet or in discovery responses. The courts will require each plaintiff to provide details about, for example, the dates of their exposure, location of exposure, in pharmaceutical cases, the prescribing physician, and details of their alleged injury, including the dates of injury, the type of injury they're claiming, and their treatment. Often, courts have required plaintiffs to provide documentation supporting these allegations. So, for example, you'll often see courts requiring a statement from a doctor stating that he or she prescribed a certain drug to the plaintiff and or diagnosed a certain plaintiff with their alleged injury. Similarly, in the environmental and occupational exposure cases, courts will require plaintiffs to provide records documenting their exposure to these hazards. Some courts have required plaintiffs to provide expert reports describing their theories of both general and specific causation. And the level of detail here really has varied. Some courts have required plaintiffs simply to provide the names of the experts that they're going to be using at trial. Some courts, like the Vioxx court, has said, well, we don't really need a full-on expert report that would be sufficient to survive a Daubert challenge, and you don't need to use the expert you're going to use at trial, but you do need a minimal showing consistent with Rule 26, showing that there's some kind of basis to connect Vioxx to each of the alleged injuries. There are cases, however, where courts have required plaintiffs to provide full-on Rule 26A2 expert reports as part of these Lone Pine questionnaires. Other courts have required plaintiffs to answer questions about specific or issues or defenses in the case, such as a statute of limitations defense. And some courts have taken even a further step back and required individual plaintiffs to affirm that they were and still are interested in pursuing the case in the first place. So we've mentioned a couple times this class action that the four of us have been working on against various tobacco companies in Florida. And in that case, there was some concern in the federal docket as to whether each of the several thousand cases on that docket were in fact being pursued by individual plaintiffs who wished to proceed with his or her case and or who authorized the filing of the complaint in the first place. And as a result of this concern, we were able to convince the court to require each plaintiff to fill out and return a Lone Pine questionnaire. And that questionnaire asks each of the individual plaintiffs, to provide basic factual information about their claim, but also to answer this question that you see up on the screen, which is, are you willing and able to participate in this case? This question has also been asked at other Lone Pine questionnaires, including the Fosamax case, which, again, I'll focus on later in the presentation. Other courts have also required the plaintiff's attorneys to certify the Lone Pine questionnaires. And again, in this tobacco litigation, the federal court in Jacksonville required plaintiffs' counsel to attach to the Lone Pine questionnaire for each plaintiff a Rule 11 certification, which really raises these questionnaire responses to the level of a pleading with all of the resulting consequences for the filing attorney. So you may be wondering when typically these Lone Pine questionnaires are ordered, and it really varies here among the cases as well. There have been a number of cases, such as the Lone Pine case itself, where the court orders Lone Pine questionnaires before discovery even begins. For example, in this Strudley case, which was actually issued last year out of a Colorado state court, it was a fracking case. And as in Lone Pine, there was an initial concern raised about the legitimacy of plaintiff's claims because of a government report talking about that particular hazardous site. A Lone Pine order was also issued very early in the Acuna case, which is approved by the Fifth Circuit Court of Appeals. And in that case, the court said, we need Lone Pine questionnaires in order to identify the individual diseases and injuries claimed by each plaintiff, because that information was not provided in the complaint. Some courts, on the other hand, including Vioxx, the Vioxx court and the Fosamax court, have held off on issuing or requiring Lone Pine questionnaires until fairly after some or even a lot of discovery has taken place. And those courts have really used that discovery as a justification of sorts to place additional burdens on the plaintiff. In other words, they say, the defendants have produced all these millions of documents, they've sat through all these depositions, and so it's not unreasonable to require plaintiffs to step up to the plate and provide some more information about their individual claims. I just wanted to note briefly this issue of settlement. Plaintiffs have argued in some Lone Pine cases against Lone Pine questionnaires and said, you know, these are really premature until the parties have reached some sort of mass settlement agreement or are close to reaching such an agreement. But courts really have largely rejected that argument outright and said that really has nothing to do with the information that we're seeking. So what else do plaintiffs' counsel say against defendants who are seeking Lone Pine questionnaires? A lot of the arguments that you might predict. Plaintiffs have argued that Lone Pine questionnaires cut out their right to discovery. They've argued that Lone Pine questionnaires interfere, and the potential dismissal of their claims interfered with the protections that they're entitled to under the rules governing summary judgment. And of course, they'll often claim the questionnaires are overly burdensome or premature. And some courts have rejected requests for Lone Pine questionnaires on one or more of these bases. But more commonly, you see a uniform response by the courts to these arguments, and that, again, is Rule 11. And the quote you see on the screen here is, again, from this Fifth Circuit case, the Acuna case. And what this court says, as most of them have, is that these Lone Pine questionnaires really require plaintiffs to provide information that they should have had before they filed their claims under Rule 11. And to wrap up, I just wanted to focus on a recent case so everyone can sort of see how Lone Pine questionnaires have evolved over time. And to do that, I want to focus on this Fosamax case. This is a decision from the Southern District of New York in November of last year by Judge Keenan. And this Lone Pine order came in response to a third request by Merck for a Lone Pine questionnaire. And in support of this request that was granted, Merck cited statistics showing that a number of these cases were being voluntarily dismissed by plaintiffs as the cases were both activated for discovery and set for trial. Plaintiffs, on the other hand, argued that, well, the MDL has really fulfilled its mission. It should go ahead and send the cases back to the home districts, and argued that the Lone Pine questionnaire was premature because the parties had not reached a mass settlement. The court found that Lone Pine orders were appropriate at this time, And based on the statistics provided by Merck about plaintiffs voluntarily dismissing their cases, the court stated that it had reason to believe that there were meritless cases lurking in the thousands of cases still on the docket. And again, the court honed in on this Rule 11 theme and said that a Lone Pine order would simply impose a minimal burden on plaintiffs, asking them to produce information that they should already have. The court noted that issuing a Lone Pine order and requiring plaintiffs to fill them out would ensure that only plaintiffs with the truly legitimate cases are compensated, and that the court would only spend its resources on the viable cases. The court rejected plaintiffs' argument that Lone Pine order would be premature because they hadn't reached a settlement. Again, it just said that really doesn't have anything to do with it. And the court also limited its order to claims from which the most meritless cases had been found to date. So the court tailored the Lone Pine questionnaires so that it was not requiring plaintiffs who are alleging the main injury in that case to provide Lone Pine questionnaires. It only required questionnaires from the plaintiffs alleging the more random or questionable injuries like swollen gums, broken teeth, and jaw pain. For each plaintiff that was required to fill out a form, the court required them to provide a completed plaintiff profile form, authorizations for medical records, and a full-on Rule 26A2 expert report. And finally, as in the tobacco cases, the Fosamax court required each plaintiff to provide a signed statement affirming their willingness to proceed with that individual case upon remand. I would just note that this Fosamax case really does provide a good overview of the Lone Pine questionnaires, so for those of you who are interested in reading more about it, I would suggest taking a look at that case. It will be included with materials that you'll be receiving after our presentation today. And thank you for your attention. I'll now pass the microphone on to Daphne.
Thanks, Carrie, very much. And to remind everyone, I'm Daphne O'Connor, and currently I work in-house, but before I went in-house, I worked at Arnold Porter with both Peter Grassi and Carrie Arnold on pharmaceutical litigation, including the diet drug litigation. And there was a period of time during that litigation for about a year where we really focused on examining and challenging the plaintiff's screening program. And we created a task force, which Peter named at the time the 10th Mountain Division, which, for those of you who don't know, the 10th Mountain Division is a division of the U.S. Army, which trains in Colorado at very high altitudes and in very harsh conditions. And they trained, this was during World War II, specifically so that they could be aggressive in the European mountain ranges during the war. And so our little task force was called the 10th Mountain Division, probably because Carrie and I were in Colorado, but also because we were fighting a very harsh battle. And so in addition to the diet drugs, similar type task force exist in other litigations. There have been challenges in both asbestos and silica. And that's what I'm going to talk about for the next 25 minutes or so, is ways to look at and challenge plaintiffs' screening programs in mass tort litigation. So first question is, where are you going to find these mass screening programs? And they're typically in situations where a few plaintiff firms have created thousands of claims through a screening program, and they file them in a short period in a couple of very plaintiff-friendly courts. As Peter talked about, it's typically going to be state courts with favorable judges, and the defendants will then, of course, focus on trying to remove those cases to federal court so that they can get the cases all in one place and focus their challenges. And recently, and just to state the obvious, which, I'm sure everyone is aware of this, but the reason the plaintiffs do this is because they want to create leverage and try to force defendants to settle cases. They don't want defendants to spend the time and money trying to segregate the wheat from the chaff and figure out which cases are good and bad. They'd rather them just settle en masse. And so, and that worked. It's worked in the past, but more recently, judges have disqualified some of these mass screening programs. And so the defense bar should really think about, doing the discovery and developing the challenge to these screening programs going forward. Of course, everyone's familiar with Daubert. Daubert is what provides you with the legal basis to challenge these types of programs. Expert opinions have to be reliable. And the question that comes up in these screening programs is, what is reliable for purposes of diagnosing someone with a medical condition? And not surprisingly, the answer is that what is reliable in a clinical practice is what should be reliable in the courts. And that seems like common sense, but in these mass screening programs, the doctors actually end up using legal definitions for some medical conditions instead of clinical definitions, which is what gets them into trouble. In the diet drug litigation, this was the late Judge Charles Walsh was the judge in the New Jersey state courts where some challenges were brought to screening in diet drugs. And he explained, in his opinion, disqualifying some of the plaintiffs' screening, that the law requires that a physician function in the courtroom as he or she would in an operating suite or clinical practice. Same with Judge Janice Jack, who some of you all, I'm sure, will recall. She issued an opinion a few years ago in the silica litigation that got lots of publicity. And again, she made the note in her 270-page decision that the doctors there seemed to be under the impression that they were practicing law rather than medicine. So this concept that doctors really should do for the courts what they're doing in their medical practice kind of underlies the basis of the challenges that I'm going to be talking about. And as I said, the screening programs have been challenged in asbestos, diet drugs, and silica, and there really are 9 hallmarks of these programs. And you can split them out any way you want, but it's helpful to look at each of these because if you're looking at a screening program going forward, these are areas that are ripe and fruitful for developing any sort of Daubert challenge. So, hallmark number 1. You'll typically see that lawyers are doing the recruiting. It's lawyers and not doctors who look for patients. And, in the typical product liability case, a patient is diagnosed with some sort of medical condition by their doctor, and they are concerned that it was caused by a product or a drug, and so they go and try to find a lawyer. The exact opposite is true here. In litigation screening programs, you've got many people who don't even know or aren't even necessarily concerned that they have a condition, and instead they see an advertisement and they decide to go get a medical test because the lawyers have recruited them. And you all have seen these types of ads on television and in print, but you'll have blanket mailings to mailing lists, there'll be newspaper advertisements, and in the diet drug cases, the plaintiff's lawyer spent, over $51 million just on the TV commercials. This here is just an example. There are hundreds, but this is an example of one of those advertisements. You'll see in the middle it says, there's a free echocardiogram which is offered to users of fen-phen, and there's a 1-800 number. And this is typical for what you would see. The same was true in the silica cases. There were also mass mailings and toll-free numbers. And so the way the lawyers recruit the plaintiffs is, through these mass-type advertisements. The second hallmark is the technicians. Technicians who are unsupervised by doctors actually perform the testing, and they perform it in, quote, non-medical settings, which I'll explain in a moment. But it helps a little bit for this section to understand just a tiny bit about the diseases at issue here. In the silica case, we're talking about a lung disease. It's caused by inhaling very small pieces of sand or silica. And typically, the people who are exposed to it are people in sandblasting or in other industrial type situations. Asbestos, you all know, is asbestosis from breathing in asbestos. I would note that both silicosis and asbestos, while they're both lung diseases, they appear very differently on x-rays, and they're easily distinguished by readers of x-rays. And then in diet drugs, the disease at issue, it was a heart valve condition. It's called regurgitation. It's when your heart valves don't close properly, so some blood flows in the wrong direction in your heart. And that condition is diagnosed on an echocardiogram, which is the test that's done. It's kind of like an ultrasound type test of your heart. So none of you would be surprised that technicians perform these types of testing. When you go to your own doctor and you get an x-ray or an echocardiogram or any other sort of test, technicians are often performing them. But the difference here is that none of the techs are supervised in these mass screening programs, or rarely are they supervised by doctors. When you go to the doctor, you have a test in a hospital or a medical office or somewhere else, and there's some doctor supervision. In these medical screening programs, that's not the case. Instead, the tests often take place in mobile units. Sometimes they set up the testing in law offices or hotel rooms. And so in the Silica litigation, Judge Jack noted that the screening company had a mobile van that they parked in the parking lot of the Sizzlin Steakhouse or a Kmart. In diet drugs, they used hotel rooms a lot of the time. And in fact, the companies that perform the testing were created oftentimes by people who had very little experience in medicine. In diet drugs, there was a 20-something-year-old echo tech who created his own company to perform echocardiograms, and he ended up making about $10 million in 1 year by doing echoes on over, thousands and thousands of people. The same was true in Silica. Judge Jack noted that a 21-year-old junior college dropout created his own company, and he ended up making over $4 million doing x-rays on 6,000 people in a very short period of time. In addition, his company performed pulmonary function tests, which, typically you need some medical training to perform a pulmonary function test, and he had a 3-day course to learn how to do it. So the bottom line is, on this testing, that while it's not unusual to have techs performing the testing, it is unusual not to have them supervised, and it's certainly unusual for people with very little training to be doing it. And so that's one of the hallmarks you should look for in these screening programs. The third hallmark is that the techs don't follow standard protocols, which is probably not surprising considering they don't have much training and they're often put their companies together very quickly. But this is another one of the hallmarks. So in asbestos, there were technicians often used the wrong PFT procedures, and they often also would send x-rays for multiple reads. So typically when you get an x-ray, a doctor reads it and you're done. It's either positive or negative. In the asbestos litigation, and this was true also in the silicosis litigation, is if an x-ray was read as negative, then it would just simply be sent to another doctor to see if the other doctor read it as positive. And in fact, they were known to send x-rays to as many as 6 radiologists until they got a positive reading. In diet drugs, the problem there was that the technicians would do a variety of things. They could change the settings on echocardiograms to make the abnormality look better or worse. In addition, they set some of the testing, which I'll show you in a minute, to exaggerate the abnormalities. And in addition, they often did, because they were doing these in law firms, there were people, either lawyers or paralegals or sometimes secretaries of the law firm who were present at the time, who created pressure on the technicians to get a higher hit rate. This is an example. I'm not going to explain any of the details behind the technical aspects of echocardiograms, but this is a very obvious and simple example. You'll see here, this is just a freeze frame from an echocardiogram, and what you look for in diagnosing regurgitation is that you see the white spot that's circled in the middle of the picture there. And so the white spot is supposed to represent what regurgitation is, and one of the ways to measure regurgitation is to figure out the area of that white spot. And there were ways that technicians could take a little cursor and essentially trace the white spot, and then the computer will calculate the area automatically for you. And in diet drugs, we would often see frames like this, where a technician, I guess you could say he was tracing the white spot, but it's clearly way outside the white spot. And so you're including a lot of area that should not be included. And so, of course, the overall area and the overall problem is way overstated. And in fact, there was one doctor, a cardiologist named Dr. Razak Tai, who is in Kissimmee, Florida, who did this. And we did a lot of discovery on him, the diet drugs, and ultimately the U.S. Attorney's Office ended up prosecuting him for 6 counts of mail fraud, 7 counts of wire fraud, and he was convicted in September of 2012. He was supposed to be sentenced in December, although I haven't seen anything about that. And the potential sentence is 20 years for each of those counts of fraud, so 260 years of jail time potentially and a $3.25 million fine. So it's serious business. And in some of these cases, I think part of the reason the U.S. Attorney's Office ended up going after him is because of the challenges that we developed in the litigation. And then, of course, in silica, same problem with the x-rays being reread multiple times. So hallmark number 4, the doctors basically disavow any doctor-patient relationship. So in the clinical setting, a doctor has a relationship with his patient. He's taken an oath. He has to abide by his oath in caring for his patient. In the mass screening programs, doctors expressly try to disavow any doctor-patient relationship because they don't want to have any responsibility to the clients. And that's what they call them a lot of times in deposition and that sort of thing. They call them clients rather than patients because they don't want anyone to confuse their medical obligations with the legal task that they're performing in these screening programs. Now, in diet drugs, the doctors were actually express about it. Some of them required that there be a disclaimer on the face of the echocardiogram report. You'll see the note down at the bottom here, which says, interpretation of the study by the above-named physician does not constitute a doctor-patient relationship. And they basically wanted to be clear that they were not making a diagnosis for purposes of medicine. They were simply making a diagnosis for purposes of the law. And of course, what this allows doctors to do is to evade the rigor of their professional obligations. Judge Jack noted in her Silica decision, again, in contrast to practice at his clinic, while at the litigation screenings, the doctor didn't do any of the things he would do in his practice. Didn't supervise the selection of equipment, didn't select who was going to do the x-ray, didn't select setting up the equipment or the amount of radiation. And so the doctors working for the screening lawyers basically believed that, by not having a doctor-patient relationship, they could provide diagnoses under a lesser standard than they would in their medical practice. One doctor, in fact, used the disclaimer of the doctor-patient relationship to defeat a malpractice claim. This was a case where the plaintiff, is Adams versus Heron. Adams was a coal miner who had been exposed to asbestos, so he went to get a screening x-ray from Dr. Heron. Dr. Heron read that x-ray as not showing asbestosis, but the x-ray did show a large lung cancer tumor. Dr. Heron made no note of the lung cancer tumor because his only job was to look for asbestosis on the x-ray. And so after Mr. Adams died, his widow brought a malpractice suit against Dr. Heron, but Dr. Heron's defense in the case was that he did not have a doctor-patient relationship with Mr. Adams, and therefore he had no obligation to tell him about the lung cancer tumor. And unfortunately, the Fourth Circuit agreed with him. So the fact that you can, that you try to disclaim this doctor-patient relationship can create some very odd circumstances. The fifth hallmark I'm going to talk about is the fact that the doctors disregard standard diagnosis protocols. So in addition to the text disregarding standard procedures, so do the doctors. As all of you know, I'm sure most medical conditions are not diagnosed solely on the basis of a medical test. You often have to rule out alternative causes or other causes for a disease. That's certainly true for heart valve disease, for silicosis, and asbestosis. So, a doctor typically needs to know about the person's medical history, sometimes where they've traveled to, their work history, that type of thing. But in these screening programs, the doctors, almost very rarely met with actual patients and rarely talked to them, and instead would get information, if they got any at all, from the lawyers or the law firms. So, and the law firms, sometimes the information was collected by paralegals, sometimes by these screening companies I've been talking about, sometimes by secretaries, and would just be handed to the doctors, and the doctors would sort of accept it. In diet drugs, one doctor, a lot of them admitted that they never met the individuals that they were diagnosing. And they took the position that it was not their duty, it was the law firm's duty to take a history and to give them that information. Now, in the diet drug cases, there was a form that you could submit in order to get settlement benefits. And that form actually required the doctor to certify that certain alternative causes did not exist in the case. This is just a copy of the front page of the form so you can see what it looks like, but this is the page that has the certification that's required. And you'll see here it's just a list of the various conditions that could cause heart valve problems other than the diet drugs. And in hundreds of cases, these forms that just all no would be checked every single time. And when we asked doctors about it, they explained that these answers were based on information that was collected by law firms. And in fact, one doctor said that because he'd never met with any of the claimants, he could just check no for all of these causes because since he had no idea, to the best of his knowledge, what the answer was no. Obviously, that makes no sense, and judges recognize that. Judge Jack found a similar problem in the silicosis cases. None of the doctors took occupational or medical histories. They didn't perform the x-rays or exams. They didn't talk to any of the plaintiffs. And Judge Jack noted, that she was particularly offended in the silicosis cases that doctors would diagnose patients essentially, with life-threatening disease and yet never follow up with any of the patients or any of the patients treating doctors. The sixth hallmark relates to the money. So lawyers are compensating the doctors through fee arrangements that bias the results. And there really are two problems here. One problem, which is what I'll talk about right now, is the fact that the doctors are just being paid large amounts of money. And so whenever you're being paid large amounts of money, you are at some level, beholden to the person who is paying you those large amounts of money. And the other problem, which is what this slide refers to, is that the lawyers would actually pay more to a doctor if the doctor diagnosed the patient with the problem. So in early asbestos cases, diagnosing doctors were actually paid more for a positive read than for a negative read. And I don't have to explain how that biases someone to decide that they're going to read positive if they possibly can. In diet drugs, Judge Bartle was the judge in the federal court where most of the cases were removed in Pennsylvania. And Judge Bartle rejected the diagnoses of one doctor who had certified 3,000 claimants, but had only spent minutes reading each echocardiogram. And he noted in his opinion that the mass production operation of this doctor would have been the envy of Henry Ford. And this was a doctor who, some of her reads actually were automatically signed, electronically signed, and some of them just seconds after the test had completed. So almost impossible for the doctor to have truly read the echocardiogram and spent the type of time that would be required in a clinical practice to review the test. And so you have these mass operations where people are making tons and tons of money. And And here, this is an example of the bias situation. As I mentioned, in asbestos, if you can just pay somebody more for a positive read, that's very clear. That happened in silicosis, which I'll mention in a minute too. Some of the law firms in the silicosis cases only paid if the person was positive and they signed up with that particular law firm. But in diet drugs, usually the plaintiff's lawyers paid the same amount for the echo reads, regardless of whether it was positive or negative. But the problem came in a slightly more complex way. So if you were actually positive on your echocardiogram, then you could submit one of those green forms I showed you a moment ago. And the green form could only be submitted if you were positive on your echocardiogram. So what the law firms would do is, pay the doctors the same price for an echo read, but pay them an additional, and usually that was, $200, $300, $400 for the echo read. But then they would pay them an additional $1,500 to complete those green forms that took a couple of minutes to fill out. So if your echocardiogram was positive, you had the chance to get an additional $1,500 to fill out the green form. And that really was clearly biased, and it was noted by Judge Bartle in his decisions on this case. One of the other things that happened, and I think I may have a quote from Judge Bartle, but one of the other things that happened in diet drugs that I'm just going to mention for a second is that there was a contingency type arrangement that was done. And in some of the cases, the law firms actually told the doctors that they could read the echo, submit the green form, but they would only get paid after their clients received payment from the settlement. And so Judge Bartle also noted that in his decision, and he referred that firm to the New York board. So the seventh hallmark really relates to what I just was talking about. Screening doctors are biased by the inordinate amount of compensation they receive. As I just talked about, you've got these mass programs where the doctors are reading hundreds, thousands of tests over a very short period of time. One doctor in the diet drug litigation got $2.5 million over the span of 10 months. Another doctor made $5 million in less than 2 years. And then in the silicosis cases, the same was true. There was one doctor there, actually multiple doctors, who gave up their clinical practice specifically because they were making so much more money doing screening programs that they thought that was a more lucrative way to spend their time. So let's see, hallmark number 8 is prevalence of injured people reported by litigation programs far exceeds independent epidemiologic predictions. And this was true both in diet drugs and in silicosis. In diet drugs, there happened to be good epidemiological studies that were done that sort of predicted the amount of valve regurgitation you would expect to see even in users of diet drugs. And Judge Bartle explained in his decision that the number of claims that were being submitted was completely at odds with that epidemiological evidence. Judge Jack made the same note in her decision. She talked about the fact that a leading study on silicosis suggested there should only be 8 cases per year in the state of Mississippi, and yet there were 10,000 claims submitted in 2002. So one other note on the silicosis, which I found very interesting, was, as I mentioned previously, asbestosis and silicosis are very different diseases on X-ray. But what they did in the silicosis cases is they took the list of people who had submitted claims for asbestosis and reached out to them and asked them to get tested for silicosis. And as it turned out, the screening companies managed to find both asbestosis and silicosis in about 4,000 patients, which apparently is absolutely unheard of. Leading experts say they've never in their entire career seen a person with both silicosis and asbestosis. And I thought Judge Jack's quote on this, she said, a golfer is more likely to hit a hole in one than an occupational medical specialist is to find a single case of both silicosis and asbestosis. But N&M, that was the screening company, N&M parked a van in some parking lots and found over 4,000 such cases. So sometimes the epidemiology can really be your friend. And if the numbers of cases are completely out of whack with what the epidemiology suggests, there's obviously a problem. Another thing you can do, although it can be somewhat expensive, is to actually review the claims that are being submitted. In the asbestos cases, there was a study that reviewed 439 x-rays and only found 3% of them were legitimate. And even in the asbestos trust, which used a more relaxed standard, they would accept a positive finding if either of 2 doctors had read the x-ray positive. The 10 doctors who were used most often failed 63% of the time. And then in diet drugs, there was a trust that audited a certain percentage of the claims, and they found that only 12% of the claims that were submitted to the trust were positive. The other thing you can do, and which we did do in the diet drug cases, you can actually try to get the court to appoint its own independent doctors to review the testing. And we did that. Judge Walsh reviewed independent doctors who had reviewed the results of independent doctors who reviewed the questionable testing, and he used that in his opinion, rejecting the plaintiff's echocardiograms. So, what are the consequences of unreliable litigation screenings? Some of this is obvious, but I'm going to state it anyway. Of course, when you have thousands of claims, you're overtaxing the judicial system. And if you've got, if you have 2,000 claims and there are 50 or 100 of them that are legitimate, then obviously those 50 or 100 people are being denied access to the courts. And their claims are going to get shuffled in with the thousands of illegitimate claims, and they either may never rise to the surface, or it's going to take a lot longer for them to rise to the surface to try to get compensation. In addition, when you diagnose people who are actually healthy with a disease, it can cause damage. There's mental anguish associated with believing that you have a life-threatening disease. You all of a sudden have a condition that you may have to claim on any health insurance application, so your premiums could go up. And you could even be actually harmed. There was one worker in the asbestosis litigation who ended up committing suicide after receiving the results that had been mailed to him of his x-ray, and with no explanation and no conversation with any doctor. And so, the other problem is that if someone truly does have a disease, there may have an alternative cause, something else that is causing it. And with no follow-up from the doctor and no ability to meet with a doctor, some people could be at risk for having treatable conditions that potentially could go undiagnosed and untreated. One other problem is that, sort of the boy who cried wolf problem is that, public health officials are going to sort of ignore these overdiagnoses because they know it's part of litigation. And there could be, a true health crisis that occurs where you're not going to get a response because people are sort of immune to these massive numbers of claims. And Judge Jack noted this in her decision. She said, there's a risk that government entities, employers, and the public will learn of the misdiagnoses and then fail to take steps that could prevent other worker exposures. So what is the role of the defense bar? You should use Daubert to try to convince the courts to exercise their gatekeeper responsibilities in reviewing these types of screening programs when it's appropriate. We should encourage clients to spend the time and the money and the energy to do the discovery that's required from not just the doctors and the techs, but even sometimes the law firms, because sometimes the employees of the law firms were actively involved in the screening programs, and so you may need to depose, paralegals or secretaries or other employees of plaintiffs' law firms. And, you should encourage the courts, as I mentioned before, like Judge Walsh did, to appoint independent experts to potentially review a portion of the testing that's been done to determine whether it's legitimate. You always run into the problem that if you just have the plaintiff's experts presenting testing and defense experts saying it's invalid, it's a he said, she said, whereas when you've got the independent experts appointed by the court, they're going to listen to them and rely on them more heavily. You could also ask the courts to order independent medical exams for individuals who potentially have, who the plaintiffs at least are claiming have a condition. And then, when the diagnoses are invalid, you should argue for dismissal of the lawsuit, not just try to exclude the expert's opinion, but, seek dismissal of the lawsuit and seek sanctions when appropriate. Judge Jack ordered sanctions against at least one of the law firms involved in the silica cases, and it's not inappropriate to ask for sanctions. The last point here is, there's some law firms who are sort of repeat offenders. They've been involved in all three of the types of cases I just talked about, diet drugs, asbestos, and silicosis. Some are involved in two. But, these firms, who I'm sure many of you are familiar with, have been involved in 2 to 3 of these types of mass screening programs. And so, of course, they're the likely people who may be doing it in the future. So, with that, I am done, and I'm going to hand it over to Judy if there are any questions.
And I have not seen any questions come over on the chat, and we are close to the end of our time, so we want to thank everyone for participating today. And if you have any questions for us after the program, please just let us know. You can get the information from the link you will be sent. Thank you very much.
Plaintiff judges, very pro-plaintiff juries, and you end up litigating the cases over and over again at the pace that the plaintiff attorneys want to pursue. This allows them to take multiple shots at such things as company depositions or document production. It allows them to seek out the more favorable judges when you have the important legal issues like Daubert challenges or various kinds of causation motions. And then, of course, they get to pick their time and their place of trying cases in front of favorable judges and juries. This is all presumably to then force some large mega settlement where you're not really able to deal with the individual facts and hopefully the individual weaknesses of each case, but rather you have to go ahead and settle them all simply because you've been chewed up in all the various locales by the wolf pack. And so what we need to do on that as defense counsel is respond in a more coordinated and a more centralized way, preferably, ideally, to corral and coordinate as many cases as you possibly can in one fair MDL court. And of course, once you do that, once you bring your cases to the individual district courts around the country, you have a very good possibility of having an MDL appointed in one place and bringing all the matters before that one judge who has the time and the ability and hopefully the independence of lifetime tenure to consider the cases fairly, as opposed to some of the political things that you find in the hinterlands where you have very often elected judges, very parochial situations. There's also a side effect to this, or a beneficial side effect, in that if you're aggressive in a removal strategy to federal court, over time the plaintiff attorneys recognize this, and they will sometimes make the lesser choice of filing their cases.
And now I would like to hand the conference over to Judy Bernstein. Please go ahead.
Good afternoon. As you just heard, this is our webinar, Managing Mass Torts, Less is Definitely More. This is the third of our 4 webinars on mass torts. We have 3 speakers today. First, Peter Grassi will present ways to consolidate lawsuits into 1 or 2 jurisdictions by various methods, which includes removal, motions for fraudulent joinder, and MDL procedures. Peter is former chair of A&P's litigation department. He was named the senior statesman of the National Product Liability Bar by Chambers each of the last 5 years. Peter is currently on the law school faculties at Harvard, Penn, and UVA, where he teaches courses on product liability. Second, Carrie Arnold will discuss pre-discovery methods of gathering information on plaintiffs with a focus on Lone Pine questionnaires. Carrie is a partner here at A&P. She's been involved for a number of years in pharmaceutical and tobacco mass torts. Carrie is currently managing as well as trying the Engle tobacco cases in Florida. And in cleanup, third, we have Daphne O'Connor, who will discuss ways to defeat medical tests and diagnoses commissioned by plaintiffs' counsel. Daphne is Vice President and Associate General Counsel of Altria and a former A&P partner. Daphne has had extensive experience managing and trying both pharmaceutical and tobacco cases. Please use the chat tool today that's within your WebEx to ask questions throughout the program. If we have time, we will try to answer your questions, but if we don't get to your questions, you can contact us after the call and we'd be happy to answer them for you afterwards. As you just heard, your lines are muted, but if you do need help, press star, then 0, and you'll get assistance.
In the state court, which is your home. For example, in the case of American Home Products and Wyeth in the diet drug cases, we found that by being aggressive on federal removal, the plaintiffs saw that, and so they brought cases in the Philadelphia Court of Common Pleas in Philly, or in New Jersey, the two home fora of American Home Products. This is not as ideal as having all of the cases in one federal court, but it's obviously better than having scores, perhaps even 100 different courts around the country where you have no local presence. And then again, in those courts such as Philadelphia or New Jersey, they're also familiar with this phenomenon, and you can get somewhat coordinated treatment there. So you're dealing with maybe 2 or 3 main courts in which you have to operate. Now, some of us tried to do this and get involved with this in 2005 when the Congress passed the Class Action Fairness Act, which I'm sure many of you are familiar with. And if you are, you know that there's a provision in that act that is supposed to apply to something known as mass actions or mass tort actions, generally defined as 100 or more lawsuits with a common nucleus of fact or law. Those of you who have dealt with this, however, know that in the past 5 or 6 years, this has become something of an empty promise. The plaintiff attorneys are clever enough to be able to file these lawsuits in groups less than 100, very often individually or in small numbers. And unfortunately, the courts have not been willing to aggregate these cases at the request of the defense. It's still something of an open question in the law, but very important jurisdictions like the Ninth Circuit, the Seventh Circuit, have held that they simply will not aggregate these.
This event is being recorded and may be posted on Arnold & Porter's website, or will be available to the public. For your convenience, shortly after the program, we will send a link with presentation materials to all the participants of today's program. And lastly, I want to announce our 4th webinar in this series, Mass Tort Litigation, All's Well That Ends Well. Details will follow on that program. I'm going to turn it over to Peter Grassi.
Good afternoon. As Judy said, I'm going to start out by discussing methods for corralling or controlling mass torts that are filed all over the country. And obviously the point here is that if you can get hundreds or maybe even thousands of cases organized in 1 or 2 favorable and more fair jurisdictions, you can then employ some of the techniques that Carrie and Daphne are going to be talking about to winnow and reduce the number of the cases overall, to make sure that discovery is done efficiently and fairly, and to be sure that when the cases are ultimately tried, they're tried in some fair manner. The first problem, of course, though, is that that's exactly what the plaintiffs don't want. They have been very clear over the years about the fact that they want to follow something called a wolf pack strategy. And this indicates that even when the plaintiffs are actually coordinating their activities, as they used to at ATLA, or I guess now they like to refer to themselves as the American Association for Justice, they will nevertheless file cases all over the country in favorable courts to them. And so I'm sure many of you have found yourself in places like West Virginia, Beaumont, various portions of Mississippi, and then, of course, always Madison County, the one in Illinois, not the one with the bridges that we all like so much. And you find yourself there before very pro cases that when Congress said 100, it meant 100, and they will not, at the defense initiative, put those cases together. And so as a result, the defense bar has to fall back on the old-fashioned forms of federal jurisdiction, most obviously diversity jurisdiction. And on paper, this should work, since generally these are cases brought by citizens, plaintiffs of one state, against a defendant who is not a citizen of that state, who has his principal place of business and his state of incorporation in some other state. And I think that to some extent, the defense bar has been too passive about the importance of diversity jurisdiction, I like to go back to the very beginning and talk about the fact that diversity jurisdiction, which you can find in your pocket constitution, Article 3, Section 2, is one of those fundamental rights that we're supposed to have in this federalist system. And you can go all the way back to the comments of Alexander Hamilton in one of the Federalist Papers, where he argued in favor of a national judiciary who would provide an impartial, fair tribunal where you do have the suits between citizens of different states. And I think it's good to remind the courts sometimes that the defendants really do have this right to diversity jurisdiction. It is not merely a matter of congressional largesse or judicial largesse. It's not a mere procedure. It's something that you're really entitled to. Now, of course, the problem there is that the plaintiffs, the Wolfpack, have figured out ways to try to avoid diversity jurisdiction. And what I'll be talking about for the remainder of my time is the issue of fraudulently joining a local defendant. As you all know, if you were paying maybe a little more attention than I did to my first year